All right, let's begin. Welcome everyone to another event in the 2023 In Conversation series. I'm delighted to be joined today by Saya Hassan and Henna Parmar for a really timely and important discussion about the Canadian bail system. This is a topic about which I know almost nothing, so I am very excited to learn about this topic with you. Just so you know, we have many exciting events in the series coming up, including a few unpublished events, so feel free to visit our website for more information about those events, including an April 20 discussion on digital ID, surveillance, and privacy, as well as a May 18th event on protests and democracy, and a few events in June on the relationship of the state in Quebec to religious organizations. So feel free to check out the website for more information about upcoming events. These events could not be hosted without the generous support of Canadians like you. All of our educational initiatives, all of our legal initiatives are funded by Canadians. We accept no government funding. So if you would like to become a donor today, I'd invite you to visit the Justice Centre and find a way to contribute to our important projects. Today's discussion is a little smaller than other discussions. This is a more technical niche issue than some of our other issues. And so we're going to have a conversation, and Saya and Henna have invited people to raise their hands at any time throughout the discussion to advance their own questions. So feel free to raise your hand and they will call upon you to ask a question. All right, I'm now going to introduce today's speakers. So Saya Hassan graduated from law school at the University of Ottawa in 2006 and was called to the bar in 2007. She articled with Walter Fox and Associates, a boutique criminal defense firm in Toronto, where she was hired on as an associate and continued her criminal defense career for over 13 years. For the past 2 years, she has worked with the Justice Centre for Constitutional Freedoms to defend the charter rights and freedoms of Canadians against quarantine hotels, vaccine passports, and limitations on Canadians' rights to freedom of religion and peaceful assembly. Saya is also the author of a book called The Practitioner's Guide to How to Present and Prepare Bail Hearings. Henna Parmar was called to the Ontario Bar in 2020. She earned an Honours Bachelor of Science from the University of Toronto. In 2019, she earned both a Canadian JD from the University of Windsor and an American JD from the University of Detroit Mercy. After law school, she completed her articles at a criminal defense firm in Toronto, where she assisted with cases ranging from first-degree murder to kidnapping to confinement. She currently practices constitutional law and has appeared before various levels of court, including the Ontario Superior Court of Justice and the Federal Court of Appeal. So please join me in welcoming for today's conversation, Saya Hassan and Henna Parmar.
Thank you, Luke, for that wonderful introduction. And good afternoon or morning, everyone. And thank you so much for joining us today. Before we jump in, I just want to briefly introduce Saya and I. I met Saya at Walter Fox and Associates when I was an articling student, and Saya was an associate who had been practicing criminal defense for 14 years. She's done countless bail hearings and has even written a book about bail. And during articling, I also had the opportunity to assist Saya with some bail hearings. We also have developed a bail course together that's intended to educate the public on bail and how it works practically. And we've had the amazing opportunity to work with many different community organizations to present our course. And we are very passionate about this topic. We hope that after today's presentation, you all will have a much better understanding about the Canadian bail system and how it works. And the question that we're aiming to answer in this presentation is whether the Canadian bail system is too lenient. As you may have heard, over the past 6 months, there have been a very unfortunate series of tragic incidents where police officers have been shot or murdered during the course of their duty. And this has raised numerous questions and concerns about whether the bail system is too lenient. And to put our presentation into some context, I do want to leave you with some recent examples. The first, just this month in Edmonton, a 16-year-old male was accused of shooting 2 police officers responding to a 911 call regarding a family dispute. And it's also alleged that the male was responsible for shooting an employee at a nearby Pizza Hut just days before the incident. And it's also alleged that this youth was suffering from mental health issues. And another tragic incident occurred a few months ago in Ontario, where a very young police officer was shot. And unfortunately, he didn't make it. He was responding to a call about a truck that had fallen into a ditch. And it's alleged that one of the individuals who shot the police officer was charged with possessing firearms and assaulting of police officers in the past, but was released on bail with numerous conditions, including that he was to stay at home under house arrest and not possess any firearms. Allegedly, he had initially been denied bail, but was released on a bail review a few months later. And this string of shootings has caused all 13 premiers across Canada to call for changes in the Canadian bail system. The premiers have written a letter to Prime Minister Trudeau urging him to consider changes to the Canadian bail system. They are advocating for a stricter bail system that makes it more difficult for people who are charged with firearm offenses to be released on bail. And the premiers are seeking a tougher reverse onus system for firearm offenses that would require someone that is charged with a firearm offense to justify why they should not be released on bail. And this private members bill, also known as Bill C-313, is being proposed, and the purpose of the bill is to amend the Criminal Code of Canada to increase this burden. Saya is going to be discussing more about the reverse onus, as well as how receiving bail may not be as easy as it may seem to a lay person. And she will also be talking about the substantive portion about bail to give a clear insight on how bail actually works. And since Saya and I are both charter litigators, we'll also highlight some of the charter sections that are engaged in bail. And we will end our presentation with some thoughts on bail reform. And as Luke mentioned, but just as a reminder, questions are welcomed at any time throughout the presentation. And we do hope that this is more of a discussion. So we'd love to hear your thoughts as well. And Saya, I'll turn it over to you.
Thank you, Hannah and Luke, and hi everyone. Thank you very much for being here. It is nice that we have a very small group. I think it will facilitate more discussion, which is really the purpose of this presentation, because Hannah and I don't have all the answers. We also have a lot of questions and a lot of thoughts, but we would love to hear from you as well. So please feel free to raise your hand at any time. I'm going to start with talking about where does the right to bail come from and what exactly what is this right? So the right to bail comes from the Charter, Section 11E, which says that everyone has the right not to be denied reasonable bail with cause. And what's important is the words reasonable bail and with cause. So what this means is that an individual or any individual that's charged with an offense has a constitutional right to this reasonable bail without cause. Without cause means that the onus typically is going to be on the government. And so when somebody is accused and they go in front of a bail court, the presumption is that the person should be released. And it's the Crown's duty, the government's duty, to convince the court why this person should not be released. So that's what without cause means. But there are, and this is something that a lot of people who are not directly involved in the criminal legal system might not know, is that a lot of serious offenses, such as the gun offenses that Hannah has mentioned, drug-related offenses, anything to do with drug trafficking, murder, serious offenses have reverse onus. And I'll talk more about that later, but what reverse onus really means is that when you're arrested for, let's say, a gun charge and you're taken before the bail court, the presumption is that you should not be released. And then it's your job to convince the court why they should release you. So that's called reverse onus, and it's much more difficult if you're in a reverse onus situation to obtain bail. And why do we have this right to bail? It goes back to the charter again, section 11D, and the presumption of innocence. Because anyone that's charged with a criminal offense has the right to be deemed innocent until proven guilty in a court of law. And in a free society, we don't want people who haven't actually been convicted of a criminal offense to be sitting in prison and rotting in prison, because it can take months or sometimes even years for these cases to go to trial. And so we want to make sure, as a free and democratic society, that there are mechanisms in place to ensure that innocent people or people that haven't been convicted in a court of law aren't sitting in jail for months or years awaiting trial. Because just because someone is arrested of a criminal offense, it doesn't mean that they're guilty. And I think a really good example of that is the hardworking truckers and the peaceful protesters during Freedom Convoy. They were doing nothing but exercising their right to peaceful assembly, and yet they all found themselves in this horrible situation where they were criminally charged. But so we don't want situations where somebody is innocent or somebody hasn't been convicted and they're sitting in jail waiting for trial. And that's why we have the right to reasonable bail and we have the presumption of innocence until proven guilty. Now, what does reasonable bail mean? Generally speaking, as I mentioned, the onus is on the government to prove why a person shouldn't be released. So if you're not charged with gun or drugs or murder, really serious charges, if you're going before the court for the very first time, the presumption is you should be released, and it's the Crown's job to prove or to convince the court why you shouldn't. But if it's a gun charge or other serious charges, it's your job to convince the court why you should be released. Generally, the court is coming in with a presumption that you should stay in prison because you've been charged with a really serious offense. And it's really difficult at this point at the reverse onus to actually gain bail and be released on bail. And I think this is something that a lot of people who aren't involved in the criminal legal system may not realize. Because what we do see is what we see in the news, the really bad cases, the various sort of cases that stand out, like the ones that Hannah referred to earlier. But there are these safeguards in place in the actual bail system that we have, one of them being the reverse onus, to ensure that if you're charged with a really serious offense, you're not just let into the community in a way that you will harm people in the community. And part of that with the reverse onus is the release plan. So what is the release plan? The release plan is the plan that you have to present to the court to tell the court exactly what you'll be doing and how you'll be supervised if you're released from jail. And the really important part of that is a surety. So that's really the first thing that you will need, especially if you're charged with a gun charge, with a drug charge, anything that's really serious. The court is going to want to have one or potentially two or sometimes even three sureties. And sureties are people that know you really well. So your family members, relatives, maybe a really close friend who is going to be able to vouch for you and tell the court basically that they're going to be your jailer. So if the person is out, the surety is the jailer. It's the responsibility of the surety to make sure this person comes to court. this person abides by all the bail conditions, and this person does not commit any crimes. And it's quite difficult, I have found in my own experience, to find a surety if you're the kind of person that is in drug trafficking, that deals with guns and gangs, because these people tend to burn so many bridges. Their families don't trust them, their friends don't trust them, they don't have anyone that can come forward and act as a surety for them. And so this is one of the safeguards. And if you're charged with something really serious, if you don't have a surety, you're not going to be released. And so if you've burned all your bridges, if nobody trusts you, if you have nobody in your life that can vouch for you, you're not getting bail, period. No surety, you're not going to get a bail. So that's a safeguard that's in place. And depending on how serious the charge is, sometimes the court is going to say, you know what, I want more than one surety. I want assurance that this person is going to be properly supervised at all times. I want 2 sureties or even 3 sureties. And it's, again, very challenging to be able to find 2 people, 3 people to come forward and vouch for you and say, yeah, we're going to watch you while you're out for months until, or even for years, until you're able to have your trial. And then another safeguard that's in place is when somebody steps up as a surety, they have to pledge a certain amount of money. And depending on how serious the offense is, the money, the amount of money is going to be higher. So if you're charged with a gun offense, the court is going to look at your sureties and they're going to want a good chunk of money that is going to be pledged, which means that if you breach your bail, then your surety may lose the money that they've pledged. If you breach your bail, the government will come after the surety and they will take that money from your surety. So this is a great incentive for the surety to ensure that they're doing what is appropriate. They're supervising the client, the accused person properly, because nobody obviously wants to lose their savings, the money that they've worked really hard for. And the courts always look at the financial situation of the surety, and they always pick a number that if this person was to lose this money, it would really hurt them. And that just gives that additional incentive to the surety to make sure that they're taking their responsibilities very seriously. And then once you have, this is difficult enough to find a surety and even to find 2 or 3 sureties. But once, if you have the sureties, then the next thing that you have to do is you have to present a plan to the court. And if you're charged with a gun charge or anything to do with violence, serious offenses, the court is going to want you to be living with your surety. So it's not enough that you just have somebody come forward, you have to live in their home. And the court is going to look very carefully at, where does this person live? Do they have a room for you? Are they going to be able to accommodate you for a long period of time while you're waiting for your bail? The court will look very carefully at these factors. So you have to live with your surety. There are times where the court is going to want 24-hour supervision because the charge is very serious. And I remember I did a bail many years ago of this individual who had been charged with counsel to murder. He had allegedly given money to someone to murder an individual in Toronto. And so very serious offense. And the person that he had given the money to was an undercover cop, which is how he was arrested. It was almost impossible to get this individual out on bail. And what I was able to do was we had 3 sureties who were men, 6 feet tall. They would be able to contain this guy if necessary. 2 were his sons, 1 was the uncle. And they all volunteered that they would take 8-hour shifts in the home at all times. And so this person would be under 24-hour supervision by 3 people who were large enough and able enough that if anything went wrong, he tried to leave the house, they would be able to contain him and they would be able to call the police. So it's not and this was very rare situation where you can actually find 3 people who are willing to come forward, who are willing to say, I'm going to dedicate 8 hours a day just to supervise this person. It's almost impossible. Like, that was really the only case I can remember where we were able to put that plan together. But all of that to say, it's very, very difficult. And the more serious the charge that you're charged with, the more supervision is the court going to want. And the more difficult it's going to be for a lot of accused to even come up with these requirements. So if you have a place to live with your surety, then there's going to be other conditions as well. The court doesn't want people to be just sitting at home doing nothing, because they can just be in jail doing nothing. They want to see people taking steps that are going to improve them in some way that is going to be helpful. So they want to see people either working or going to school. If somebody's not working and not going to school, there will sometimes be a condition in there that says you have to actively search for school and get yourself into school, or you have to actively search for a job. If there is a mental health issue, which in a lot of offenses, I have found in my own practice that mental health is a big factor. A lot of people suffer from serious mental health issues, and the support is not there. You can't get the help that you need, and things just keep getting worse and worse until you commit a very serious offense. So if mental health is a problem, if addiction is a factor, the court will always put a condition in there that says you have to get help. It's mandatory because it's part of your bail. And not only do you have to get help, but you have to let your surety know exactly what you're doing. You have to grant permission for your surety to speak to your doctor, to speak to your counselor, to make sure that you're on the right track. Because what I have found, and I think it's just very paramount in the criminal legal system, is that if people don't have the proper tools, for example, if you have an addiction and you don't deal with it, or if you have anger issues and you don't deal with it, you get convicted, you go to prison, you serve your time. Nobody ever comes out of prison a better person than when they went in. You're going to come out more damaged than you were before. And if you don't have any tools to deal with your addiction, to deal with your mental health, to deal with your anger issues, you're just going to come out and commit another crime, and back to jail you go. And so you have this revolving door. And that's why bail is a very complex issue, because we're dealing with so many different aspects of it. And I think mental health, addiction, that kind of thing is really important as well. It's something that we don't look at as much as a society, but it does play a really big role. And I know at least in one of the these tragic events that have taken place in the last 6 months, was one of the accused persons had a serious mental health problem. And you don't wake up one day and have that serious mental health problem. It usually starts slowly and it just gets better. It gets worse as time goes on. So the courts always, when they see that there is an addiction or there's a problem, they will put in conditions in your bail that you have to get help. It's not optional, it's mandatory. And this is, again, another sort of tool to ensure that when these people come out of jail, if they're convicted, if they serve their time, they have some tools they can use to not reoffend again. And then with the very serious charges, you're definitely going to have house arrest, which means you cannot leave your house at all times. You have to stay at home. Sometimes there will be a condition that you can leave your house if you're in the presence of your surety. But otherwise, you have to stay at home. And the incentive to make sure people do this in most cases, because sometimes people obviously don't abide by their bails, but the incentive is that if you have a condition that you have to be under house arrest, the police is allowed to come to your door any time of the day or night and knock on the door to see if you're there. And you never know when they're going to come or if they're going to come. So at all times, at any minute, the police might come to check on you. And if you're not home, you're going to get breached, you're going to get arrested, and you're going to be put back in prison. So that's another safeguard in place, and it's another incentive that if you're under house arrest, and of course you have your sureties, but you also have this additional barrier that police may show up to your door at any time. And I'm giving you all these examples because I have found, and what I read in the news is quite different from the reality of bail. It is quite difficult to get bail. And we only hear in the news about, the really, the one case or the case that is really violent, really outrageous. And so it's easy to kind of assume that this is how the bail system works and it's really lenient and everybody can get out. But in reality, it's extremely difficult for people to get bail, especially if they are charged with something serious as a gun charge, because you have that reverse onus and all these steps that you have to meet, which many people are just simply not in a position to meet. Let's see. And then another factor that the court will also look at is if you have a criminal record. And so let's say you have a conviction for a gun charge, and then you come out, you're charged again with a gun charge. The court is going to look and see, well, okay, you were charged, you went to prison, you did not learn your lesson, here you are again, probably not going to let that person out. So that's another factor that the court is going to take into consideration. They're also going to look at, do you have any breach convictions? Have you ever breached a bail condition? If you have something like that, well, clearly you're not trustable, you're not going to listen to the court, you're not going to get out. So there's lots of safeguards and lots of factors that the courts are going to look at when deciding if they're going to grant bail to someone or not. And I think breach of bail is important because that's something that we've seen quite a bit in the news. But breaching your bail has extremely serious consequences for people. And breaching your bail means that you didn't abide by one of the conditions that were given to you, or if you commit a different offense while you're out on bail, all of that will be considered breach. And the first thing that's going to happen is you're going to get arrested. And you're going to get charged with breaching your bail, which is a completely separate charge from your initial charge. So if you were charged with a gun charge and now you're arrested for breach, you have two criminal charges that you have to deal with. And the courts take breach charges extremely seriously because they see that as an insult to the court. They see that as an offense to the court because you were disrespectful to the court. You did not follow the conditions that they set out for you. And so it's very difficult to beat a breach charge. If you're charged with breach, you're probably going to get convicted and you will definitely go to jail, even if it's your first time. If it's your first time and if it's not a very serious breach, you're looking at 15 to 30 days of jail. If it's more serious, you're looking at more time. And then if you breach again, the time will go up. You're going to serve more time and more time. So it's very serious. And I've had clients who were acquitted of the charge that they were initially charged with, but they got convicted of the breach, which meant they still ended up with having a criminal record and the consequences that comes with a breach. And if you have this breach on your record, and if you ever get arrested again, the court is going to look, oh, you breached your bail, you're not trustworthy, we're not going to release you on bail. Very serious consequences that come with breaching your bail. And these are all incentives for the majority of people who are released on bail not to breach their bail because nobody wants that extra charge. That means you have to pay your lawyer extra money to defend you. You're most definitely going to get convicted. You're going to go to prison. Nobody wants that. So it doesn't deter everyone, but it's definitely a deterrence for the majority of the people that are out on bail. And then the other thing about breaching is your surety. So you have a surety, you breach your bail, you cannot present that surety again in court because the court will say, well, this was your surety, you breached your bail. Clearly, this person cannot also be trusted to be your surety. Then you have to go try to find somebody else. And in most cases, nobody else is going to come forward for you. So if you breach your bail, you're getting into a lot of trouble and you're very likely that you're not going to get bail again. You're going to sit in prison until you go to trial.
If I may.
Nonetheless- Yes.
Sorry,
please.
Saya. I believe
Absolutely.
we have a question from Francis.
Yes.
Hey, guys, just thank you to the Justice Center for putting on these terrific presentations and our guests. Here's my question. I mean, we have an activist court in Canada, and they've made essentially bail a default position, which in my view is contributing to an increase in crime, led to things like catch and release. So I know you said that bail is very difficult and so on, but we got repeat offenders essentially across the country committing all kinds of crimes. Wondering if you could comment on the activist position, the default position, and then on the federal Liberals putting in play identity politics for when punishments are handed out. Thanks.
Thank you. In terms of, I'll start with the default position because I don't agree with you. There is default position, which is the Crown onus for things that are not serious. But for anything that is serious, like a gun charge, there is no default position. The position is reverse onus, which means the presumption is you should not be released. That is the presumption that you're going to be starting with. So that's where you are. And then it's your job as the accused person to convince the court why you should be released. That's the default if you're in reverse onus situation. And with respect to courts and activism, I think what I would say is bail is very straightforward in terms of there's a test that the court has to look at and the court has to say, okay, is this person, it's a 3-step and I'll just lay it out very easily for you. First is it reverse onus or is it Crown onus? That's the presumption. Then the court has to see, okay, is this person gonna show up to court? Do they have any, roots in the community? Do they have a family? Then they're gonna see, is this person the kind of person that's gonna abide by their conditions? And they're gonna look at, does this person have a criminal record? Is he out on bail? Has he ever been in trouble before? All of these are factors, as well as, who's the sureties, what is the supervision plan, how likely is it that the supervision plan is gonna work? And then there's the tertiary grounds, which is actually used quite often, and probably a lot of people who are not involved with the criminal legal system don't know about this, but it's a ground that considers, even if, let's say, the person meets the first 2 grounds, the tertiary ground says, if we release this person, is that going to bring the administration of justice into disrepute? So that's the ground on its own. And even, let's say the court says, okay, you will show up to court and you will abide by your conditions, but this charge is just too serious that if I let you out, the administration of justice is going to go into disrepute. So that's all there. And it's a very straightforward test that the court follows. And they look at the plan and what's been provided for them. Is it perfect? No, it's absolutely not perfect. And I think we hear a lot about the parts that are not perfect in the news, but then we don't hear about all the people that actually abide by their conditions and they show up to court and they have their trials, and whether they get acquitted or they serve their time. We never hear about any of those. We only hear about the really bad apples, and they tend to be a very small group of violent offenders that seem to be, like you said, serial offenders who do what they do. It's not a perfect system, but there's certainly a lot of safeguards in place to protect the public. But I don't think there's any perfect system anywhere in the world where we can say it works 100% of the time. And I don't know if that answers your question.
No, that was good. I just, what about the last part, the federal Liberals injecting identity politics and how punishments are handed out? They look at quotas, who's been in jail, based on history, Indigenous people, et cetera. It might be others. I'm just curious what your thoughts are around that.
Sure, and I've done a lot of work with different groups of individuals as my clients, and I can tell you, the court is always going to take anyone and everyone's personal circumstances into consideration, and it doesn't matter if you're white, if you're black, if you're whatever you are. They're gonna look at, what was your upbringing? Did you have any difficulty in your life? What brought you to this point? Did you have any violence in your life? Do you have a mental health problem that hasn't been addressed? The court is going to look at all of that for every single person. And it's the job of the lawyer, and I find that this isn't always done properly or doesn't done fully, but it's the lawyer's job to make sure the judge knows their client. It doesn't matter what background they come from. It's really important that you know the history of this person so that you're sentencing the individual and not, because people are individuals, and it's so easy, I think, for the courts to forget that because they see so many people come through the system all the time. And it is really important to look at different factors. And they do look at, for example, if you're an Indigenous person, there's the Gladue principles that they will look at, but that's not the only thing that they're going to look at. They're also going to look at, do you have a history? Have you committed crimes before? Do you have a criminal record? Have you breached your bail? How serious is this offense? All of that is going to be taken into consideration when sentencing individuals, and that goes for everyone. But again, we don't hear about all the we just hear about the particular, the ones that go really, really wrong, but we don't hear about the rest of it that actually works fairly well. And judges do take the time to, get to know this individual and hand out an appropriate sentence. Does that answer your question?
Yeah, thank you.
Thank you so much. Okay, so let's see. And then I think the last thing I wanted to
the murder charge, which is the most serious charge in the criminal code. And for murder charges, in order to get bail, it's extremely difficult, but you have to do it in the superior court before a superior court judge. So it's a completely different scheme of bail for murder charges. You have to get a special time in the superior court and you appear before a judge in the superior court. And of course, you're in the reverse onus situation, which means that the presumption is you should not be released. And it's up to you to convince the court why you should be released. For all other charges, the bail usually takes place in front of a justice of the peace in the Ontario court. And sometimes the judges of lower court will also hear bails if it's a gun charge or if it's a special bail hearing where it takes a long time. But typically the bails are done in front of justice of the peace. But for murder charges, you're in the superior court, you're before a superior court justice. Again, another safeguard to ensure that things are being done in an.
And that kind of brings me, that's how the bail system works. And I hope I've left you with the impression that it is not as easy as we think or we read about in the news to get bail. It's actually quite difficult. And there has been a lot of talk about bail reform. And like I said, we don't have all the answers, but we do have some thoughts and some questions. And it is a very complex issue that I think we all as a society really need to put a lot of thought into how we can resolve it. There has been suggestions, as Hannah has mentioned, to make the reverse onus even more more strict. And it's not clear to me based on the suggestions how they would want to do that, because reverse onus already you're starting with you're not getting out. How much more stricter that can get or how much more onerous that can get, I don't know. I think that's it's a proposal out there and it's certainly something that's open for discussion. But it is important, I think, in my humble opinion, in a free and democratic society, that we don't base general laws that are going to apply to everyone. We don't base those on a few bad apples or a few bad cases that have gone wrong, because those laws are going to apply to everyone. And again, I would go back to the trucker convoy and everybody that was arrested there exercising their rights and freedoms. And there's a lot of people that never expect they're going to be criminally charged, and somehow they end up before the system, or they have a family member that somehow ends up before the system. We want to make sure that the laws are fair and balanced and not based on just those few bad apples, because I mean, no law is ever going to be perfect, I don't think. But that is one of the suggestions. And then there has been a lot of talk about Bill 75, C-75, which was a bill that was supposed to kind of revolutionize bail. And there was a lot of talk in Bill C-75 about principle of restraint, which I think we've seen a lot in the news recently, the principle of restraint. And then there's the principle that release the detainees at the earliest reasonable opportunity. And then there's another phrase on the least onerous conditions. And when you look at it like that, well, this person is going to get released at the earliest reasonable opportunity and on the least onerous conditions. That makes the bail system terrible. It's not strict enough. But this is very nuanced. So when we're talking about earliest reasonable opportunity, in real life, how the bail works is you do have to be taken before a court within 24 hours. But just because you come before a court doesn't mean that you're going to get released. A lot of bail courts, especially in busy cities like Toronto, but I've seen that just generally in Ontario, there will be 20, 30, 40 matters in a bail court every single day. And if you're going to do a bail hearing, the bail courts can usually do 1, maybe 2 bail hearings per day. So that means if you have 30 people who need to have bails, only 2 of them are going to get a bail that day. And everyone else is going to get put over to the next day and the next day. And I have seen people sit in jail for 3 weeks, 4 weeks, 5 weeks, just waiting for the chance to have their bail hearings. So when we say earliest reasonable opportunity, typically it takes a while for people just to get a bail hearing because the courts are really overburdened and because bail hearings take a long time. I mean, 1 bail hearing can take half a day, 3/4 of a day. So you're not going to be able to do more than 1 or 2. And then when we talk about release on the least onerous conditions, again, it depends on the offense. So if you went to a bar and you had a fight and you got arrested for assault, you're going to have very different conditions that are least onerous than if you are charged with having a loaded gun. Then in your case, the least onerous condition is probably going to be you need 2 sureties, you need full supervision, you can't leave your house. So it's nuanced. It really depends on what are you charged with. And that's going to define what is the least onerous condition. And if you have a gun charge as well, you can't just go to the bail court and have a bail hearing. You have to set a special date. They're called special bail hearings. And that will take 2 weeks, 3 weeks just to get a date for you to have a bail hearing. It has to be done in a special court because it takes a long time to do bail hearings for gun offenses. Again, you're sitting there, you're not really being released quickly. It takes a long time. And once you have your bail hearing, you better have all of your ducks in a row and have all of your sureties, which most people simply don't have, and they don't get released. And then the last thing I wanted to talk about with the Bill C-75 is they also came up with this concept called judicial referral hearing, which was supposed to streamline breaches of bail. So if somebody breached their bail, but it was done in a non-violent way where they didn't harm anyone and there was no violence, it was supposed to be taken out of the bail court and done similar to like a traffic court. It would be more administrative rather than criminal. And I can tell you in all the years that I practiced after Bill C-75, I never ever saw that being used by the Crown, not once. And I've spoken to so many other criminal lawyers to see if they've ever seen it or experienced it. It has never been used to the best of my knowledge. And I've certainly never experienced it. And that would have been perfect, for example, for someone like Tamara Leach, who was arrested for a breach that didn't involve violence, didn't involve anyone getting hurt. So she could have easily been streamlined into that judicial referral hearing if that was something that the Crown and the government was doing. But we know that that's not what happened, and she was arrested and put in prison and brought before the court. So if you look at that bill, it looks like there's a lot of lenient things in there, but when you look at it practically, some of it is just simply not practiced at all. And the rest of it is very nuanced, and it really depends on what you've been charged with. And I think that's kind of everything that I wanted to talk to you about the bail. Is there any questions out of anything that I've raised before I turn it to Hannah for a conclusion? Yes, please.
Thanks,
Is it
guys.
Francis?
Francis, yeah. Just a quick, I guess, maybe a little bit of a rebuttal on your
Sure.
few bad apples. Crime in Canada has been increasing, at least over the last 3 years. I mean, total murders are up way beyond 700. The last time we had reached that, that's way above in the past. So I'm curious to explain, there's a lot going on. Crime is, just here in Toronto a few days ago, a 16-year-old was killed on the subway. Some individual just a random attack with a knife.
Yeah, I heard about that.
Yeah, a few bad apples are creating a lot of carnage. It's curious. There has to be, I think, a connection between bail reform, the Trudeau's bail reform. Trudeau's bail changes, the Supreme Court, and all this additional crime. I mean, from my reading, my research, and I wrote an article on this stuff, I see a rapid increase in crime. Just your comments on it.
Well, I think part of it would depend on how much of this crime is from people that are out on bail. And I don't have that statistic. What I know is that it's a very small number. The majority of people, if they're out on bail, they're keeping their head low because they don't want to breach their bail. Are there people that abuse that and they breach their bail? Absolutely. And that's why we have the reverse onus. But I think that's one of the issues. And then the other issue, and a lot of people may not agree with me, but what I see in a lot of these serious offenders is serious mental health problems. For example, Hannah and I worked on a murder case when she was articling, and this person had started having really weird mental health problems 6 months, I think, prior, and he was keeping a diary of it. His wife kind of was watching, but wasn't able to get any help for him. And so this went on for 6 months, no help, no support. He ended up killing someone, beating a homeless man to death. But the major factor here was his mental health. So what can we do? And this is something that's overlooked so often, but there are people who have really serious mental health problems that are not being dealt with. There's no support for them. And then they just keep getting worse and worse, and they go out and they commit crimes. And I have sat in bail courts, especially in the drug courts, and I would see people be brought up, and these people, you can just tell clearly they're not okay. They have mental health problems. They're asking, they're like, well, where's the mental health worker? Like, where's my support worker? There's nobody in the bail court that's going to help you. And you have no one because you've now burned all your bridges and you're an addict and nobody cares. So nobody's going to come and show up for you. So you're going to go, you're not getting bail. You're going to plead guilty just so that you can get out. You're going to go out there, you're going to commit another offense, you're going to get arrested, and it's going to continue. I think we can look at bail reform, but part of that has to be, in my opinion, mental health. And what do we do with all these people who have serious mental health problems and there's no way for them to get help? What do we do with that? And how do we protect the society from that?
Thank you.
Thank you. If there's no other questions, then I'll turn it over to Hannah.
Do you mind, Saya, if I ask a question of my
Yeah,
own?
please.
I actually have two questions. So the first is, there seem to be some cases of people getting released on bail, and our intuition says that should not have happened. In your view, is this a misapplication of the requirements for bail, or is this some problem with even the most perfect application of the conditions for bail?
It's so hard to tell because I don't know what the conditions were. For example, I was very interested to find out this individual that was released who killed a police officer who was on bail. Like, I'm very interested to know what was his bail plan, because there must have been a serious bail plan in order for a judge to let him out. But I don't know. And I think it would really depend what was the plan. And then also, sometimes, I mean, the system is not perfect. Again, I wish it was, it simply isn't, but I can't make a comment on whether this was done correctly or inappropriately because I don't know what the plan was. I do know that he was sitting in jail for quite some time before he was able to get bail, and I'm assuming he was trying to put together some kind of a release plan. And then the other part of it is the minute the surety realizes something is wrong, they need to call the police. That's part of their responsibility. And most people will do it. Some people won't do it. I don't know if that was the case here, if the surety let the police know or what happened. But it's really, I think, hard to tell. It depends on what the plan was.
Mhm. Thank you very much. And if I may, I have one more question.
Please.
So you say that people who are charged with an offense have a right to a bail hearing within a reasonable amount of time, but due to the burdens on the court system, many people aren't able to get a bail hearing for some time. And yet there's this other administrative tool that would allow at least take some people out of the court system into this lesser kind of administrative court. Why isn't that happening? I mean, why does Tamara Leach, for instance, have to wait some time for a bail hearing when there's this other tool of justice, I don't know, to solve the problem? Do you have a sense of that?
I don't know. It's a good question for the government because it's something that I know a lot of defense counsel were kind of wondering about. And part of it is it has to be a breach that doesn't involve any violence or any harm to anyone. So some of the breaches, obviously, they will have violence. But in Tamara's case, I think hers would have been a perfect example of something that could have been streamlined. Why isn't it done? I think we have to ask the government. It's I think it should be done because that would kind of take the burden off of the bail system, and then people could have their bail hearings more quickly, and you don't have people languishing in jail for so many years. I should say a caveat is that I haven't done a bail hearing in
years. So maybe things have changed, but while I was practicing, I never saw that done. And I've spoken to many defense counsel who also never saw that tool being utilized.
Right.
Yeah.
Thank you.
So that's not much of an answer, but we have to ask the government. I don't know why they won't do it. It's in the bill.
Yeah, makes sense. Thank you.
Yeah.
Henna, I
Yes.
suppose we will turn it over to you.
Thank you. So we wanted to end the presentation by talking about some things that we, Saya and I, believe are important to consider in bail and bail reform, but aren't discussed enough. And as we've seen in the past 2 years, especially with COVID, the media really can exaggerate things because, you know, they want to get a story out. But in reality, as Saya mentioned, it can be quite onerous to receive bail. And unless you have that knowledge about the criminal justice system, a layperson may not have that understanding. And since Saya has touched on this extensively, I don't want to go into it too much, but unfortunately, like Saya mentioned, the reality is that many people that are charged with criminal offenses, they are victims themselves. Not all the time, but from our experience, most of the time, they're victims of mental health issues, addictions, victims of abuse and crimes that were committed against them. And so when they don't receive the help that they need, it is that revolving door. And like Saya mentioned, no one comes out of prison a better person. And, you know, employers can deny people jobs if they know that the individual has a criminal record. And so if this person doesn't have a job or any support, and they don't get the help that they need, that's kind of where the repeat offending, we tend to see that repeat offending. So like Saya mentioned, that's something that's really important to consider. And another big consideration is the delay in the justice system, which has only gotten worse now because of COVID. And we have people who are convicted of a criminal offense in jail for such long periods of time. And having trials within a more reasonable time frame can allow people who are convicted to either be sentenced and serve their time, or if they're found not guilty, they can be acquitted and come back into the community rather than being in bail for so long. And it'll also ensure that trials are heard on their merits instead of being dismissed due to delay. We have seen the Crown drop charges because of the delay, and it's taken years for someone's matter to come up in court. And again, we do have the presumption of innocence in the charter. And as we've seen over the past 2 years, especially, it's so important to defend our charter values vigorously. And I know Saya knows this, our articling principle, what my articling principle would always say, you know, if we know that people who are charged of the most serious offenses are having their rights upheld, then we know that everyone in society will have their rights upheld. So that is really important. And we don't have any perfect answers. And Saya and I have extensive conversations about this all the time, and we haven't been able to come up with the perfect answers. But these are things that we wanted to leave you with to think about. And unless anyone has any more questions, that's the end of our presentation.
Well, I have another question,
Go
if I
ahead.
may. So this may be a naive instinct, but it comes to mind whenever I hear about courts requiring, I believe, sureties to put up pledges on behalf of individuals who have been charged with crimes, and that the courts find some amount that will significantly harm or hurt the surety if the conditions of bail are breached. I'm not sure if my problem with this is very articulate, but does that generate any concerns about fairness or about inequality or about, you know, placing a harm, like the potential for harm on an individual who's kind of coming in to support somebody who's been charged with an offense? Does that make sense?
Yeah, I think I understand, and you can tell me if I don't, but so the court is going to look specifically at the particular surety and at their financial situation, and then the amount is picked based on that situation. So the general idea is that if you're releasable, if the court decides that you should be released, you're not going to be kept in jail because your surety can't afford $100,000. So maybe your surety is a working mom who is a single mom and has $2,000 in the bank in their saving accounts, but that's everything that they have. So that means a lot to that person. And so maybe the judge is going to say, well, you're going to put up that entire amount. And if this person breaches, I'm taking all of that money from you, and you're not going to be able to feed your child. So they do look specifically, and they ask questions about, do you own a home? You know, what is your income? What do you have in your savings account? And then they pick a number based on that person's a specific financial situation so that it hurts them. But I mean, if it's a $2,000 for this person, that's really hurtful. It's not going to be the same for someone that's make $100,000 a year. They're going to have something completely different. And I don't know if that answers your question.
No, it does.
Uh-huh.
I was unaware that the amount the courts required would depend on the individual circumstances of the sureties. So that.
Yeah, absolutely. And it's part of our job as lawyers to get all of that information and present it to the court. And sometimes a lawyer will also speak to the surety and they will say, okay, we're only comfortable putting up, let's say, $15,000, and that's all we're going to put up. I always say or suggest to the clients, let's just leave it to the court. Because if you say, I'm going to put this amount up, but you have more money, then the court is going to say, well, don't you trust this person enough to put up this much money? Why are you only putting this much money? And so that's not helpful. You just present, I think, all of the financial picture of the individual, and then let the court decide what they think is appropriate and what is really going to be a significant amount for this particular surety.
Right. Excellent. Thank you.
Francis has a question.
Hey, guys. Yeah, just curious to get your take on the use of hypotheticals. Hypotheticals, is this something specific to Canada? Is it a worldwide phenomenon in courts? And is it there really just to aid the defense? Because, you know, in my research, and I went through a bunch of cases, some of the time, hypotheticals don't have anything to do with the actual facts in a case. And judges use it to determine an outcome, even to overthrow toss out a certain law or whatever it is. Just curious your take on hypotheticals. Are they being abused? Do they have a useful, is it a useful tool? Just curious.
When you're talking about hypotheticals, I think you're referring to charter cases, for example, minimum sentences for guns, that kind, right? Not the bail. Yeah, so I am familiar with that, and they are used quite often in criminal cases. So I think I think that there's a place for the hypotheticals. And so the situation will be, and I agree with you, a lot of the times the hypothetical is not going to have anything to do with the person that is being charged and their circumstance. But the judge will look at the hypothetical and the judge might say, you know what, this law is unconstitutional, but they're still going to look at the accused as they stand before them and look at their condition and their charge and how serious their situation is. And that person is going to get sentenced based on their circumstance. So they're not getting sentenced on the hypothetical. So while the hypothetical can be used to say the law is unconstitutional, it's not going to impact the sentencing, because the sentencing is going to depend on the individual, and it's a very individualized process. Does that answer your question?
Do they use it in the US? I'm just curious. Do they use it in the US?
I don't know that. I'm not familiar with that. But we do use it in Canada in criminal cases. And I think it can be used to say strike down the law, but it's not going to be used in sentencing. It's going to be still, what did you do and what are you responsible for? And I know of cases, I can't think of the name off the top of my head, where the law was struck down as unconstitutional, but the person still got that minimum sentence because of the circumstances of their offense and what they had done.
Very good. Thank you.
You're welcome.
I believe the case is RV Nur. It's a Supreme Court of Canada decision.
Thank you, Hannah.
So unless there are any other questions, we'll ask one final question of you both. This is a more technical niche issue than many of the other issues we address in this series. But what can Canadians do to be better informed about the bail system, both those who have been charged with either non-serious or serious crimes, and ordinary Canadians like me? What can we do to stay informed about all of the issues surrounding bail and the possibility of bail reform?
Hannah, do you want to go first?
Sure. So for me personally, I think doing your own research and educating yourself, again, I'm just coming back to COVID. It's so important to keep yourself well informed, because a lot of the information that's presented may not be the whole picture. I know there's a lot of free legal resources like CanLII, for example. I volunteered with them. They have a free criminal constitutional book, and it has all the charter sections and criminal sections and bail as well. And it's a free resource and people can read up on it and inform themselves. I think that's something that's really helpful, and what we as the public can do to be more informed.
Yeah, and I agree with Hannah. And I found that it was really difficult to find accurate, helpful information about bail online. And I remember I was in court once and I was watching this lawyer do a bail review, and I could tell it's his first time. And I was just cringing because he was just not doing what it was just not going well. And that's why it led me to write the book that I did. And this is not to promote my book, but just to say that I just didn't think that there was a lot of information available online. Now Hannah's free CanLII book is out, so I think that's super helpful. But the reason I wrote the book was it's really for the public as well. It's written really simply. It's a sort of a handbook on how does the bail actually work, and if somebody that you know is arrested, what are you going to look for? I think it is really important to inform ourselves. And while the news, I mean, it's there and it's in our face all 5% of what is going on, and there's the other 95% that we need to kind of do our own research and figure it out. And you can always reach out to the Justice Center. We're always here and happy to help and inform people as well.
Of course, we are a phone call or an email away. Well, thank you very much, Saya and Henna, for a very excellent and informative conversation on this subject. I learned a lot. For you who attended, we will be sending out an email next week with other resources, such as Saya's book, such as Henna's book, such as other relevant articles. We will also be sending out a recording of this conversation. So if you'd like to listen again, please do. As I
Thank
mentioned at the
you.
beginning, there are many other events in this series. On April 20th, Justice Center lawyer Keith Pridgeon will be joining us for a conversation on digital ID, surveillance, and privacy. And while we haven't announced this yet, there will be a conversation on April 25th that will equip parents and teachers and elected school board trustees to engage effectively with school boards in Ontario. And then, of course, Saya will be joining us again on May 18th for a conversation about protests and their function in democracies, both from Canada and Iran. So again, everything that we do here is entirely funded by generous Canadians like you. If you would like to support a Justice Center project, I'd invite you to visit the Justice Center website, click donate, and make a contribution today. It really helps us to put on these workshops and to write research reports and to defend Canadians across from coast to coast. So thank you very much for your time, and we will see you at another Justice Center event.